and carry you over to their jail. But this was nothing but bullying. It was the ultimate desire of the city attorney, Stephen Greer, because, as I say, he's been filing in the court for over a year to lock us up, put us in jail so we will yield our God-given free will agency of choice, was what they thought, but we did not yield. But this is nothing more than home invasion by forced home invasion by court order. That's what this consisted of. Anybody in the construction business out there that hears me, because we were in the construction business for over 50 years, knows that an inspection does not include 5 or 6 men with cameras coming through the inside of a person's home that they live in. That is a search, not an inspection. They've used the word inspection to put their little legal spin on this issue. But we have complied with all the permits required from when we began this work. Now, the last week of January 2015, we had a surprise visit from the mayor of Dunlap. Face to face, he drives up in a police car. We had just hit the 90% point of restoration on this total beautiful home. Everything in it is new. The systems, the wiring, the heating and air. We have our son is a contractor. He took the state licensure back in '94, and he chose to beef it up because we're his mom and dad, and he cares about us. And he used 10 LVL beams. Anyone that's done any work knows what kind of expense that is in this larger portion of this structure. And steel bracketed these onto concrete, steel reinforced concrete pillars to set the house up to meet the FEMA guidelines. And we got those guidelines from our county appraiser of property and tax assessor, and we followed those guidelines exactly, even to the percentages of how much you had retained of the original grandfathered structure. But the mayor said, when he told us, he said there was no courtesy call, no letter. He just shows up at dark one night and says, "You're going to tear this house down. And if you don't do what I'm telling you to do, I will hurt you." My husband said, "Is this about another permit?" And the mayor said, "No, we would not give you a permit because we're going to make you tear this house down." And then he said, "We'll sue you in court." Well, the problem from that point that happened, and he is a mini tyrant. I don't know if you want to use the word mini there. He is a resident of Soddy Daisy. He lives on Soddy Lake Tributary. He bought a $500,000 home. Now, I'm talking about Dwayne Land here. And I hope there are people in Dunlap that hear this. You know it, but no one speaks up. He bought a $500,000 home, according to Hamilton County tax records, in the year 2011. That is his primary residence in Soddy Daisy. But yet he has just been reelected to mayor again in the city of Dunlap. I don't understand this. The local election commission who qualifies people to run seems like they're not doing their job over there. But there are powers that be that want to keep him in play. They want to keep him in place. He fills their deep pockets. They fill his deep pockets, and that's just the way it goes. So he got the city attorney to file a lawsuit in Chancery Court.
Against you, Carol Gaddy, and your husband, Thomas,
yes,
here in the studio.
And what that complaint stated, David, was they were seeking a court order for demolition of our home. As I have said, our home is new. It's like a new home inside. Beautifully, we structured it open because our grandchildren are grown, our children are grown, and we wanted a nice family meeting place for Thanksgiving, Christmas, for holding our family prayer meetings. It's just a nice, great room, open space. So here comes the lawsuit, February the 11th, 2015. And we answered their lawsuit, and we countersued the city for $995,000. And a lot of the portion, that may sound like a lot of money, and it did not then, and it does not now. These men, their attention to money is what matters most to them in life. They seemingly don't care about God's word that warns a man, do not be a partaker of another man's sin. You will partake of that man's judgment. They don't pay any attention to all that. So from the time 10 years before, when they asked me to sell the property to the city of Dunlap, and I said no, I did not tell them why I could not sell that property. I could not sell it to them because it does not actually belong to me. We consider anything we own as belonging to the Lord, because our Bible says that the Lord owns it all. And that's the way we look at it. Yes, we're supposed to pay the debt. We're supposed to pay the bills. We're supposed to keep it up. We're supposed to be accountable to God on what he directs us in our life and in our walk with him. So the city attorney, all the mayor had to do was just tell the city attorney to file the lawsuit against us. And of course he did it. And now here we go. 3 years. We're into 3 years of this battle. Stephen Greer has filed continuance after continuance in this case. We have filed motions to dismiss on this case on 3 different occasions. And we filed our motion for summary judgment. I'll back up a second. The initial Chancellor Stewart, recused himself when the issue of jurisdiction came up. There's another thing about jurisdiction that I want people to know that's very important. In the absence of jurisdiction, it opens the judge up for a lawsuit. His immunity is gone. If he continues to sit in judgment over that case without jurisdiction, just an individual citizen can take legal action against that judge. And of course, the judge recused himself, and we filed a motion for summary judgment, which should have ended this case on November 2016. And City Attorney Greer had not filed against that in the court filing for 2 months. All of his time was out. We finally managed to get this docketed, first time to stand before Judge Graham. And Judge Graham's own words in the courtroom was that he was not going to allow the other attorneys there, who's a part of Attorney Greer's law firm, to represent the plaintiff. He said, no, Attorney Greer is the city attorney, and that's that. And I said, very well, Your Honor, then we would like default judgment because he's not present here in the courtroom. The judge blew up. I'm talking about Thomas Graham blew up at me in that courtroom. He started yelling. He sent me to jail, claiming I was disorderly, and all I did was legally representing ourselves, tell him the legal position was that we deserve default judgment. If he was going to regard only Stephen Greer as the attorney for the city, and in his absence, that's what should have happened. This case would have ended November the 10th, 2016, if legally it had proceeded according to law. But instead, I went to jail for 2 days and 2 nights under contempt of court by Judge Graham. And then, of course, by the reschedule.
Well, did you not say, Carol, did you not point your finger at him and say, you're going to rot in jail, Judge?
No, I didn't say that.
That would be of contemptuous nature.
No, David. All I did, as they almost got me, and listen, I did not resist the deputy. The deputy did not have to handcuff me. He walked up and said, let's go. And I said, yes, sir. And I began to follow the deputy out of the courtroom to the hallway to the jail. And just before I stepped through the door, I did because this is way across the courtroom, and the judge was still glaring at me from the bench, and I just raised my right hand, and I just lightly pointed to him, and I said, you will do 10 years in federal prison for this, because he had broken the law. And I was already aware of old American law. It's called Title 18, USC, Title 18, 241, 242.
So that comment was made after he had already found you in contempt, and that was not the cause of his contempt finding.
No, absolutely.
Rather harsh comment about the judge's future domicile.
Well, David, a lot of people, if you don't read your King James Bible and you're not a born again Christian, you will not be aware that what I spoke to him is biblical principle. You must warn a person, first off, before you would file charges. And since that time, we have filed federal charges against him.
Well, speaking of notice, you did not get any kind of notice from the city that would be requisite under the exhaustion of remedies ruling, the requirement for exhaustion of administrative remedies, to have the process brought up by letter. Could you please appear before us? That's all requisite before litigation. You can't litigate a matter until you've had correspondence, you've had discussion, you have effort to reach a meeting of the minds over the purported rules and your purported rights. That didn't happen. You were just hit by a lawsuit. So there was not the exhaustion of remedies that is really important in American jurisprudence.
Yes, it's required by law. And without it, David, it creates another jurisdiction problem for the Chancery Court. And that is called subject matter jurisdiction. If you ignore the doctrine of exhaustion of remedies at law, then, and you jump over that, like jumping up a ladder, okay, that creates a subject matter jurisdiction. So this case has operated going on 3 years in a total jurisdictional vacuum.
And as I pointed out, and you say you pointed out in filings, the case cannot be filed in Chancery Court. It has to be filed in city court. Again, that's the proper step. There's hearing among the council members and the resident, and then it goes to city court. It does not go to Chancery Court. It goes to city because that's the way the charter requires it, and that wasn't done either. So it seems kind of like a mess from the city of Dunlap's perspective.
Oh, yes.
This is David Tulis. We're talking with Carol Gaddy. Both she and her husband Thomas are in the studio. We're rehearsing the story of Carol Gaddy versus the machine, the municipal government machine that can be far more aggressive against constitutionally protected rights than state or federal often. And that's because of personal interest in the matter. David Tulis, Nooga Radio. Hang on.
The Tennessee Valley's news, talk, and sports leader. Nooga Radio. Digital FM 95.3 HD4 and